My husband of 18 years, a millionaire partner at one of the most prestigious law firms in the city, came to me with tears in his eyes and begged me to adopt an abandoned baby to save our marriage. He told me she was a tragic orphan who needed a mother and that this was a sign that this was our second chance. What he didn't know was that I'm a family court judge, that I review adoption files for a living, and that 3 days after he brought home that pacifier from the hospital, I had a DNA test result sitting on my kitchen table showing a 99.9% probability that the baby was his own biological child. He didn't bring me an orphan, he brought me his intern's baby. And then he sat across the dinner table from me for 6 weeks, watching me paint the nursery, while that 22-year-old girl sat at his firm's dinner parties, smirking at me from across the room. Welcome back to Secret Confessions, True Stories. If you love stories where arrogant liars get exactly what they deserve, make sure to hit that like button and subscribe to the channel. It means more than you know, and there are more stories like this one coming. Now let me tell you how my husband tried to make me raise his own betrayal, and how I made sure the entire city was watching when I didn't. Richard and I had built what looked, from the outside, like exactly the life people spend their careers trying to achieve. He was a senior partner at Merritt & Cole, one of those firms whose name carries weight in certain rooms. The kind of weight that gets a table at restaurants that don't take reservations, and invitations to events that don't have public ticketing. I am a family court judge. I have been on the bench for 11 years. Before that, I spent 8 years as a family law attorney, which means I have spent nearly 2 decades watching people try to deceive courts about the most fundamental things: parentage, custody, the truth of what a family actually is versus what someone wants a legal document to say it is. I say all of this not to establish our credentials, but because I think it is important context for understanding the specific nature of what my husband attempted. He was not a stupid man. He was, in fact, an exceptionally intelligent man. And he looked at me, at my 11 years on the family court bench, my 8 years practicing family law, my professional life organized entirely around the mechanisms of exactly the scheme he was attempting, and he decided to do it anyway. That is not stupidity. That is arrogance of a very particular and very complete kind. The marriage had been struggling for about 2 years before he came to me with the proposal. Not struggling in a way we spoke about directly. We were both too skilled with language and too practiced in the management of professional appearances to have the kind of raw, honest, deteriorating conversations that struggling marriages actually require. It was struggling in the way that manifests as distance, as parallel lives, as two people sharing a house and a calendar and a social identity without sharing much of anything that actually matters. I knew the distance was there. I had chosen not to examine it too closely, which is its own kind of decision. He came to me on a Sunday evening. He had clearly prepared the approach. There was wine, there was a particular quality of intentionality to the setting that I registered without fully articulating. He sat beside me and he talked about purpose and legacy and the emptiness that can arrive in a good life that has not included certain specific things. And he built, carefully and skillfully, to the proposal. A baby girl, 6 weeks old, at a hospital through a private adoption agency he had apparently already contacted. An orphan, he said, abandoned, in need of a family. He believed, he said, that this was a sign. He was crying, real tears, or what appeared to be real tears. After 18 years, I had lost the ability to be entirely certain, which is its own kind of information. He held my hands. He said he thought this could be their beginning again. I told him I would think about it. I'm a family court judge. The first thing I did was review the adoption files. The agency he had used was legitimate, licensed, registered, with a functioning history of placements. The paperwork was professionally prepared. A layperson, or even most lawyers, would have found it completely in order. But I am not a layperson, and I am not most lawyers. I am someone who reads adoption files the way a musician reads a score, not just for the notes, but for what the notation reveals about the performance, the gaps, the places where something has been arranged rather than simply occurring. The mother's medical records had been redacted to protect privacy, which is standard. What was not standard was the specific pattern of the redactions, what had been removed and what had been left. Most redactions in adoption files protect identifying information, names, addresses, identifying physical details. These redactions went further. They removed information that was medically relevant but not identifying, the kind of information that would allow a sufficiently knowledgeable reader to establish a timeline. The timeline of the birth, the timeline of the prenatal care, the timeline of when the mother had first engaged with the agency. I noted the pattern. I noted the dates. I cross-referenced against what I knew about Richard's schedule over the previous 18 months. The business trips, the late evenings, the weekend conferences. I am a judge. I am accustomed to holding a hypothesis loosely until the evidence either supports or refutes it. The evidence was, at this stage, suggestive rather than conclusive. I needed something conclusive. Richard had brought a pacifier home from one of his visits to the hospital. He had been visiting the baby, which I had found touching when he told me, and which I found illuminating once the hypothesis had formed. The pacifier had the baby's saliva on it. I had his hair. I had a relationship with a forensic laboratory through my court work, the kind of professional relationship that allows for discreet, expedited processing of sensitive requests. The result came back in 72 hours. 99.9% probability of paternity. I want to tell you what that moment was like, because I think the truth of it is more complicated than rage, and I think the complication is part of the story. There was rage, certainly, the cold, clean variety that arrives when you understand that something has been done to you deliberately and with planning, and with the specific contempt of someone who believed you would not see it. But there was also something else, a professional clarity, a judge's clarity. The clarity of someone who has received evidence and now understands exactly what case they are building and exactly what outcome the evidence supports. I put the result in the drawer beside my reading glasses. I made dinner. When Richard came home, I told him I was warming to the idea of the adoption. I watched his face do the thing it did when he was managing relief, the careful containment of an emotion too large for the moment. I saw it, and I noted it, and I served the pasta, and I asked about his day. The 6 weeks that followed were the most controlled performance of my professional life, and I have presided over some very difficult hearings. I bought baby clothes. I did this genuinely, in the sense that I walked into the shop and I chose the things a woman preparing for a baby would choose. And I brought them home and I folded them and put them in the dresser we had moved into the nursery. I painted that nursery. A soft yellow, because we didn't know, or Richard pretended we didn't know, the baby's preferences yet, and yellow felt neutral and warm. I mixed the paint and I rolled it onto the walls, and I did a second coat because the first one wasn't even, and I stood in that yellow room and felt something that I will not fully describe here because it belongs to me. Richard's firm had a dinner every year for partners and their families, a formal affair at a hotel downtown, the kind of event where everyone performs the version of themselves that their professional success is supposed to have produced. I attended in a blue dress, and I sat beside my husband, and I smiled at his colleagues, and I talked about the adoption with the warmth of a woman who has been given an unexpected and precious gift. And Jade. Her name was Jade. She had been Richard's intern for 14 months. She was 22 years old and wore her confidence like a provocation. Jade sat across the room at the junior associates table. She looked at me once. It was a particular kind of look. The look of someone who believes they have won something. I smiled at her. I meant the smile. Because here is what I want to say to you, before I go on, about what it is to be a judge in that room, at that table, with that information. It is not comfortable. It is not satisfying in any immediate way. The knowledge sits in you like something cold, and the performance of not knowing is an active and exhausting thing. And there are moments when the weight of what you know and the weight of what you are pretending not to know press against each other in a way that requires genuine effort to manage. But I have been a judge for 11 years. I understand something that my husband did not, that the outcome of a case is determined long before the hearing. It is determined in the preparation, in the evidence gathered, in the procedural steps taken quietly and in advance, that mean that when the day of the hearing arrives, the result is already established. The hearing is just the delivery. Can you believe the nerve of this man? Sitting across from me at dinner parties with his intern in the room, watching me fold baby clothes and paint nursery walls, believing that his legal expertise and his charm and his certainty that I was simply too trusting to look closely had produced an impenetrable scheme. If you find this as outrageous as I did, please take a moment to hit the like button and subscribe to the channel. It genuinely helps, and there are more stories exactly like this one waiting for you. Now let me tell you how I started digging his grave. The adoption hearing had been scheduled for a Tuesday. I used my position as a judge, carefully, properly, within the bounds of my authority and my ethics, to ensure that the hearing was assigned to my courtroom. This was not improper. The assignment was random within the court's standard rotation, and I had not manipulated the rotation. I had simply not recused myself. There is a meaningful legal question about whether I should have, and I want to be honest with you that the answer is probably yes. I had a personal interest in the case, but I also had a judicial interest, which is to say, I had evidence of fraud being perpetrated upon the court, and I had the authority to address it, and I chose to exercise that authority in the most complete and public way available to me. I invited the press. This also requires explanation. The hearing was a matter of public record. Adoption hearings are typically sealed, but I used my judicial authority to schedule the hearing as an open proceeding on the grounds that the matter involved potential fraud on the court, which is a category of proceeding for which public access can be ordered. I notified Richard's firm of the hearing date. I framed the notification as a courtesy. His partners would want to be there for such a significant personal milestone, I thought. Many of them came. I also, in those 6 weeks, prepared the other documents. A divorce petition, drafted with the precision of someone who knows family law from both sides of the bench. An asset freezing order, signed by a colleague on the civil bench, applied to the joint accounts and Richard's personal investment portfolio. A formal child support assessment, prepared under the statutory guidelines, calculated on the basis of his partnership income, which I knew, having managed our taxes for 18 years, down to the last declared dollar. These documents were ready. They were waiting. The morning of the hearing was a Tuesday in October. Richard dressed carefully. I watched him select the suit, the tie, the particular combination of professional authority and personal warmth that he had been cultivating for this occasion. He was going to stand before a court and invite all of his colleagues and the press to watch him perform generosity. He believed the judge presiding would be a colleague of mine, someone who would process the paperwork with the appropriate formality and conclude the proceeding in perhaps 40 minutes. He did not know the judge presiding was me. I arrived at the courthouse separately, which was not unusual. We often had different schedules, and the pretense of separate arrivals was easy to maintain. I went to my chambers. I put on my robes. I reviewed my notes one final time, though I did not need to review them. I had prepared so thoroughly that the notes were a formality, a ritual, not a source of information. When I walked into the courtroom, the room was full. Richard's partners occupied 2 rows near the front. The press pool had 3 reporters and 2 photographers. Richard stood at the petitioner's table with an attorney. He had hired someone to represent him in the adoption, which I had anticipated. In the back row, in a dark green coat, sat Jade. Richard turned when the clerk called the court to order. He was expecting a colleague. He saw me. I watched the color leave his face in the specific sequence that indicates the body receiving information that the mind is not yet processing. I walked to the bench. I took my seat. I arranged my papers. I looked out at the courtroom. I said, "This court is in session. The matter before us is a petition for adoption. Before we proceed to the substance of the petition, I need to address a preliminary matter." The preliminary matter was the DNA test. I read the findings into the record. The collection methodology, the pacifier, the hairbrush, the laboratory, its accreditation, its chain of custody procedures. The result? 99.9% probability that the petitioner, Richard, was the biological father of the child subject to the adoption petition. I read this in my judicial voice, which is the voice I use when I am reading findings into a record. Clear, measured, without inflection, because the facts do not require inflection. The facts are sufficient. I then read the findings of my review of the adoption file, the irregular redactions, the timeline inconsistencies, the evidence that the adoption had been constructed around a child who was not, in fact, abandoned, but was the biological child of the petitioner, a child whose mother was, based on cross-referencing the timeline, a current or recent member of his firm's staff. I turned toward the back row. I said, I would also note for the record that an individual associated with the petitioner's firm is present in this courtroom, and that the timing of that individual's employment at the firm corresponds precisely with the timeline established in the biological record. Jade did not move. I will give her that. Richard's attorney rose and made an objection. Several objections in rapid succession, each one technically grounded and procedurally appropriate, and entirely insufficient to address the substance of what was in front of the court. I sustained none of them. I formally denied the adoption petition on grounds of fraud upon the court and misrepresentation of material facts. I ordered the matter referred to the State Bar's disciplinary committee for review of the petitioner's conduct, on the grounds that a licensed attorney had knowingly submitted fraudulent documents to a court of law. I signed the referral order from the bench. I then produced the divorce petition. I filed it from the bench, which is an unusual procedural step, but not an improper one. I had standing to file as a party to a proceeding in my own court, and the clerk accepted the filing. I produced the asset freezing order. I produced the child support assessment, and I delivered it formally as an officer of the court to Richard's attorney of record, who was at this point the only person in Richard's immediate vicinity who had not moved away from him. His partners left in groups of 2 and 3. I watched this from the bench. They were not dramatic departures. These were professionals, accustomed to managing appearances. But they were definitive. The press photographed them leaving. They photographed Richard at the petitioner's table, in his carefully selected suit, with his attorney, with the empty chairs around him. I said, "This court is adjourned." I stood. I left the bench. I went to my chambers, and I took off my robes, and I sat in my chair for a while, and I let myself feel, finally, what I had been not feeling for 6 weeks. Richard lost his partnership the following morning. The firm sent a letter, professional, terse, the language of institutional self-protection. He had brought the adoption fraud, the bar referral, and the photographs of his public humiliation into a firm whose reputation was its primary asset. The calculation was swift. The child support assessment I had prepared, calculated on partnership income he no longer had, was reviewed by the family court and adjusted to his actual current income, which is a substantially smaller number. He is still paying it. He will be paying it for the foreseeable future. The baby, I want to say something about the baby because she is not a character in a story but an actual child, and she deserves to be mentioned as such. She was placed with a family through a legitimate adoption process, one that did not involve her biological father attempting to offload parental responsibility onto an unwitting spouse. She has a family. She is, by all available reports, doing well. Whatever her parents' choices, she did not make them, and the outcome for her is the most important outcome of all of this. I want to leave you with the thing I have thought about most in the time since. My husband was a brilliant attorney. He had spent 30 years understanding how legal systems work, how courts function, how documents are structured and interpreted and challenged. He understood adoption law. He understood family court procedure. He understood, in theory, exactly what he was doing when he submitted those documents. What he did not understand was that he had decided to run his scheme past the one person in his life most specifically and professionally equipped to identify it. He looked at me, at my robes, at my bench, at 30 years of collective family law expertise, and he saw a wife. He saw someone he had managed for 18 years and could continue to manage. That is what arrogance does. It narrows the field of vision until the most obvious thing in the room becomes invisible. He was so certain of my blindness that he handed me the pacifier himself. He handed it to me himself. The best advice I can give to anyone who attempts to deceive a person who holds the power to hold them accountable is this: do not. Not because they will necessarily catch you, though they might, but because the assumption that you are smarter than the systems you are manipulating, that your intelligence exempts you from consequences, that the person you are deceiving is simply not capable of seeing what you are doing, that assumption is always more fragile than it looks. It is always the thing that breaks first. I know this professionally. I had spent 11 years watching it break in other people's cases, and then I watched it break in my own. Thank you so much for spending this time with me today and for listening to this story. If you want to hear more secret confessions and true stories of justice, please subscribe to the channel, leave a like, and tell me in the comments what you would have done in my place. These stories are told for you, and I am so grateful you are here for them. I will see you in the next video.